लेट अस स्टार्ट। जब दुनिया हमें कहती है हार मान लो, उस समय उम्मीद हमें कान में कहती है एक बार और कोशिश कर लो। ट्राई अगेन। होप सेज अस ट्राई अगेन, once again. Yes. A informs B that he heard that before him she killed to D. Statement of B as a witness in the court may be presumed as a hearsay evidence. Yes. Because the statement is based on hearing. One says to other and other appears to the court to provide evidences. Such type of evidences shall be called hearsay evidence. So the correct answer of the question 1 is A. A is the correct answer. For exception to the hearsay rule, under sections 17 to 39, yes. 32, 33, yes. 34, 35, yes. All the options of the question 2 is true. So the D is the correct answer. Which of the following section of Indian Evidence Act provides exceptions to the rule of hearsay evidence is not admissible? Which of the following sections of Indian Evidence Act provides exception to the rule hearsay? To the rule, it should be in inverted comma. It means if rule hearsay evidence is not admissible, which section is the exception to the rule hearsay evidence is not admissible? Section 32. Section 32 is the exception rule of hearsay, in which it is propounded that evidence shall not be produced. It means hearsay evidence shall not be produced, shall not be admissible. So section 32 is the correct answer of the question. Exceptions to the rule, hearsay rule. What is hearsay rule? That hearsay evidence should not be produced in the court as an evidence. This is the hearsay rule. Are provided the Indian Evidence Act under exception provided in which section it is provided? A is also correct, B is also correct, C is also correct. These are correct answer, but D is incorrect. If we study the question, according to the question, these three options are correct answer. But when it is said that hearsay rule are provided in Indian Evidence Act, that hearsay evidence should not be produced, which section affirm the hearsay rule? If the question is asked in such a way, which section affirms hearsay rule, then the answer shall be D. But if we study exception to the hearsay rule, the options are true. Okay, so we study, if we read the question, all these are correct answer A, B, C, so none of them, it means no answer can be given. Why? Because three options are correct according to the question. If it is said that, it is asked that in which section hearsay rule is propounded, then option D shall be correct. Otherwise, no answer is correct. Okay, next question. Exception to admissibility of hearsay evidence. Exception to the admissibility under following section. Section 32 is the exception of hearsay rule. So B is the correct answer of the question. B is the correct answer of the question. Oral evidence of the following person. Oral evidence of the following person is not relevant. Is not relevant. A person, oral evidence of the following person is not relevant. It means under following one of the person whose oral evidence shall not be relevant. So who is the person? First of all, a person who has seen a fact. A person who has seen a fact. A person who has heard a fact. A person who has perceived. All these three are direct. So these are relevant, but the question is following person is not relevant. D is the correct answer. A person who has been told about a fact and then he is produced to give evidences. So D is the correct answer of the question 6. Next, oral evidence under section 60 of the Indian Evidence Act 1872 must be direct. Yes, must be direct. Section 60 says it. Oral evidence must be direct. So the correct answer of the question 7 is A. Out of the following, which is not an exception to hearsay evidence. Which is not an exception. Actually, all these are exception. Okay, so no correct answer. It is also exception. It is also exception. It is also exception. And admissions are also. All are hearsay evidence. And here the question, out of the following, which is not an exception to the hearsay? So all options are exceptions to the hearsay rule. So no correct answer. We are unable to answer it. No answer. Hearsay evidence is no evidence. Which of the following sections of the Evidence Act is an exception to the aforesaid rule? Yes, section. Hearsay evidence is no evidence. This is the hearsay rule, and it is also in accordance with the provisions mentioned in the section 60 of Indian Evidence Act. But further we study which of the following sections of the Evidence Act is an exception. It means, what the question? The question is, which section is an exception to hearsay rule? This is the question. It means, manner of asking the question is technical. If you see, the direct question is, which section is exception to the hearsay rule? Yes, section 32 is exception to the hearsay rule. So the correct answer is B. Res geste is allowed as an exception. Hearsay evidence, yes, because undoubtedly hearsay evidence is excluded from producing before the court, from producing the evidences before the court. Hearsay evidence are not produced, shall not be produced. But there are some evidences which follow the rule of hearsay, or you can say hearsay evidence, and they are produced as an evidence before the court. For example, dying declaration, res geste, admission confession, expert opinion. Though these are hearsay evidence, and they may be produced, they can be produced as an evidence in the court, provided that they are hearsay evidence. So the answer shall be, res geste is allowed as an exception to hearsay evidence, because res geste, according to this principle, hearsay evidence may be produced as an evidence. So the correct answer of the question is C. Any opinion of a deceased expert expressed in an treatise which can be proved in the court by presenting book, yes, is kept in which of the following category of the evidence? Oral evidence. Such book shall be called oral evidence. though if you see, you find that it should be documentary evidence. But any opinion of a deceased person, deceased expert who is died, expressed in any treatise which can be proved in the court by presenting book. If the book is produced before the court, is kept in which of the following category of evidence? Such book if produced before the court, in which type of evidence such book is counted, is understood, is deemed? Actually, such book shall be known as oral evidence. This is the correct answer of the question. One rule is that hearsay evidence is not admissible. Yes. A states in the court that he heard the bomb blast. He heard the bomb blast in which people died. Age statement is admissible. Yes. Age statement is admissible. Why? Because A heard blasting of bomb, A heard, A himself heard. None tell him about the bomb blast. He hears himself about the bomb blast. So the correct answer of the question A. Oral evidence should be direct. Yes, section 60. No confusion. Admissions and confessions are exception to the hearsay evidence. Yes, it is correct. Part of hearsay evidence. No. Form of relevant evidence. Yes. So admitted in evidence on proof. No. If you see 1, 2, 3 should be correct answer, but one and 3 should be correct answer. Here 1, 2nd and 4th, it is not correct. 1, 3rd not correct. 1, 2 correct, you can say, and 2nd only. No. Here 1 and 3rd is the best option. Shall be the best option of the question. 1 and this. But if according to the option 1st and 3rd, this is the best option. So the correct answer C. 1st and 3rd. Indian Evidence Act 1872 does not expressly mention about oral, documentary, secondary, circumstantial. Yes, circumstantial evidence are not propounded. Next question. The statement of witnesses based on information received from other is inadmissible. Actually, it is based on hearsay. And if any evidence is produced, if such evidence are produced to prove anything, any fact, such evidence shall not be admissible. The statement of witnesses based on information. Based on information, it means hearsay. Other is inadmissible. Yes, correct. Which one of the following option is correct? Because the person giving such evidence does not feel any responsibility. No. Because the truth is diluted and diminished. Because there is an ample. No. Yes, D. D is the correct answer of the question. D shall be the correct answer of the question. Last question. Contents of documents may be proved either by primary evidence or secondary evidence. Here should be or. Primary or secondary evidence may be produced. Firstly, primary evidence is produced. If primary evidences are not available under section 75, any condition take place, secondary evidence may be produced. So C is the correct answer. C is the correct answer of the question. Yes. Thanking you for watching video. That's all. Okay, thank you. That's all.